Court rise.
Appeal in matter of Avonwick Holdings Ltd and Azitio Holdings Ltd and others.
Good morning.
Good morning, may it please the court. I appear with Mr Dubyna and Miss Young for the appellants. My learned friend Mr Oleh, Queen's counsel, appears with Mr Wilgar and Miss Wellen for the respondents. We have 1.5 days. Once we get to the point, it's quite a short point, but we need to get to it. My learned friend and I have had a discussion about time allocation, and the plan is that I will be on my feet until about 3 o'clock. Today, my learned friend will have the same time, taking us up to about 12:30 tomorrow, and I'll have half an hour in reply, if that's acceptable to the court.
Well, thank you very much. That's the answer to my first question. Very good.
What I was proposing to do by way of oral submission is just to say a few words about the background to the dispute, the claim, the evidence, the judgment below, and then the law.
Thank you. And obviously you can assume that we have done our best to do all of the reading that you set for us, but that in any event we have read those passages in the judgment that you highlighted and the skeletons, but we've done more reading than that.
I'm very grateful. In that case, if while I'm taking you through things, they are pages or paragraphs that we've asked you to read, I hope you won't mind if I do so to some extent, simply to emphasise particular points that we would wish to get out of material, because we are very aware that there is the judgment alone is a bit of a beast, so you may not necessarily have got what we would want you to get out of some of the pre-readings. So I hope it won't seem too repetitive. But we'll obviously try and take matters as economically as possible, and I hope you will recognise. In fact, I think both sides, in fairness, have taken a fairly restrained approach to authority. We could have smothered the court with considerably more case law and commentary, but I think both sides have taken what I hope is a proportionate approach to the citation of authority. So just simply by way of background, you'll be aware that the dispute essentially was between three wealthy individuals who, like many other wealthy individuals, tended to conduct their business dealings through corporate vehicles. And for many years they worked well together with numerous different ventures held through different entities. But the main asset, which appears in the evidence or in the transcripts either abbreviated as IUD or ISD, Industrial Union of Donbass, was the main asset. But there were, of course, many others, and the two that we are going to be concerned with is a holding company abbreviated as NET, which owned an interest in the Hyatt Hotel in Kiev, and an agricultural products company called Agro Holding. As you will be aware from the pre-reading, at some point Mr Gaiduk decided that he wanted to exit from IUD, and negotiations began with the other two, Mr Taruta.
And that was back in 2007?
Yeah, exactly so. And negotiations began with Mr Taruta and Mr Mkrtchan. They, as you will appreciate, didn't have cash sufficient to buy out Mr Gaiduk's interests outright, so they spent some time either looking for finance or for an onward purchaser of the main asset, IUD. Those negotiations ultimately led to an option agreement in July of 2009, which is not the one that was ultimately completed, but I just wanted to pause on that. July 2009, there is an option agreement for the joint acquisition by Mr Taruta's vehicle, Dargamo, and Mr Mkrtchan's vehicle, Azitio, of Mr Gaiduk's interest in the main asset, IUD. And could we just very briefly look at that, which is in the core bundle? Oh, no, sorry, it's not. It's in the supplemental bundle at tab 1. Are we all working from hard copies? I don't need to give electronic.
Hybrid.
Okay. Oh, well, okay. I just mentioned while we're getting this in front of us, my learned friend refers to this in his skeleton quite late on as a draft. I think he refers right towards the end of his skeleton to previous drafts of what ultimately became the Castle Rose SPA. This, in fact, is not a draft, and if one just looks at the very final page, it is signed by the three principals on behalf of their vehicles. If you look at page 26 in the bundle, it is signed by Mr Gaiduk, Mr Taruta and Mr Mkrtchan on behalf of Avonwick, Dargamo and Azitio. So it isn't a draft, it was an option agreement. It was an option agreement in respect to which the option was not exercised, so it was never completed. But as an agreement, it was an executed agreement. And just for present purposes, the detail doesn't particularly matter, but just in order to start getting one's head in the right place with regards to the price for IUD, it is significant. If we just look at the first substantive page of the agreement, which is page 6 of the bundle, you'll see it's dated 2nd of July 09. It's between the three vehicles, Avonwick as the seller and Azitio and Dargamo as the purchasers, and the seller is selling its shares in Castle Rose, which is in turn the vehicle through which the shares, the Gaiduk shares in IUD are held. And if we just turn over the page to page 7, you'll see just over halfway down the page, clause 2, sale and purchase of the shares. The seller grants the purchasers the option of purchasing the shares in equal proportions, and it may be exercised by notice. And the long stop date, not that it particularly matters, but the long stop date was the 1st of September. But you'll see from clause 2.4 that the consideration for the sale of the shares was 723,750,000. So just to start, as I say, by getting one's head in the right place with regards to the price for IUD, that was the agreement that was signed in July. As I say, that agreement was not completed. The option wasn't exercised, but negotiations then recommenced, and one gets to December, which is then the agreement that was not only executed but completed, and that is what has been called the Castle Rose SPA share sale and purchase agreement, and that's tab 5 of the same bundle, page 58 if you are electronic. And again, if we just look at the first substantive page after the title page and the contents, page 60 of the bundle, you'll see it's dated 18th of December 09, so that we have the same parties as seller and purchasers. And over the page, clause 2, sale and purchase. The seller grants the purchasers the option of purchasing the shares, and we don't need to go forward, there's no dispute about that. That is Avonwick's shares in Castle Rose. If you want a cross-reference, it's page 78 is where the shares are defined. The option exercised by joint notice, the exercise notice, and the exercise notice deadline, if you want, the date was the 30th of December. And then if we look at clause 2.4, we'll see that the consideration for the sale of the shares is 950 million, not the 723 we saw in July. We'll come to the detail, but I just want to walk you through the terms of the contract. If we go to page 68, just so that you have seen it, there is at clause 12 an entire agreement clause. This deed and other transaction documents contain the whole agreement between the parties, and that is a clause on which Milan and Friends' respondent's notice relies, although it's not an argument that has been developed in his skeleton. and then at clause 13.
So I think in his footnote, Mr. Dubyna
Sorry,
says
yes.
he doesn't
No.
rely on it anymore.
No?
All right.
And clause 13. Sorry, that's right.
I'll develop a point in submissions. We don't rely on it anymore, but it's part of the agreement and it is relevant. If you look at what it actually says, it is relevant to the issues that arise.
I'm grateful. We'll hear how that's developed. I'm grateful. Clause 13.1. You'll see that the governing law is English law, and then just for the purposes of identifying who owned what, it is perhaps helpful just to look at page 71, Schedule 2. I'd just like to draw your attention to paragraph 1.3. The company, that's Castle Rose, was incorporated solely to hold the 33.84 participation interest in the charter capital of ISD. So that is the vehicle through which the shares in ISD was held. That was Castle Rose's only asset. Page 78, you'll see the definition of shares. The third last, shares means all the shares issued in the capital of the company. So that agreement is signed, not in fact by the principals, on behalf of those entities, but nothing turns on that. The agreement is executed and in due course completed. The 950 million was paid, and IUD was acquired entirely by the Mkrtchan and Taruta parties, and then sold on to what has been called the Russian purchaser, which you will have seen. Now, in due course, as you know, the Gaiduk parties brought a claim in deceit against the Taruta parties and the Mkrtchan parties, alleging that they, the Taruta parties and the Mkrtchan parties, specifically Mr Mkrtchan and Mr Taruta, had told Mr Gaiduk that the price per share in IUD, which the Taruta parties and the Mkrtchan parties had agreed with the onward buyer, the Russian purchaser, was the same price per share which the Taruta parties and the Mkrtchan parties had agreed with the Gaiduk parties under the terms of the Castle Rose SPA. That is the price representation. Now that allegation of deceit obviously required the Gaiduk parties to plead what they claimed the agreed price for the shares in IUD was. And it's important, with that allegation of deceit in mind and the context in which that allegation is being pleaded, to look at Avonwick's particulars of claim, which are in the core bundle at tab 13. And if we look at page 366, the beginning of the particulars, we have paras 1, 2 and 3, the background with which you are already familiar. And then the relevant passages start at paragraph 4. A meeting took place at the office of Mr Gaiduk in Kiev in June 2009 to discuss terms for a sale. At the start of the meeting, Mr Taruta attended by telephone and indicated that Mr Mkrtchan would be speaking on his behalf. After the call with Mr Taruta ended, Mr Mkrtchan explained to Mr Gaiduk and Mr Petrov, that's Mr Gaiduk's representative advisor, that he and Mr Taruta had found a buyer who who wished to acquire a controlling interest in IUD, and that the buyer was a Russian entity that wished its identity to remain confidential. Mr. Mkrtchan proposed that a transaction be structured as follows. The claimant would sell its 33.84% interest in IUD to Azitio and Dargamo. They would, in turn, at about the same time, sell that stake plus approximately 8.5% of each of their own participation interests in IUD to the Russian buyer, thus providing it with a controlling interest of 50% plus 2 shares. And then critically, paragraph 6. Mr. Mkrtchan represented orally to Mr. Gaiduk and Mr. Petrov that the price paid to the claimant for its 33.84% in participation interest would represent the same price per share as paid by the Russian buyer to the defendants for the combined 50% plus 2 shares, the price representation. And secondly, that the Russian buyer required certain other assets, including in particular a stake in the Yalta hotel complex in Yalta, indirectly held by Mrs. Gaiduk, to be transferred. The price representation and or the first asset representation, or words of similar effect, was repeated to Mr. Gaiduk and or Mr. Petrov on various occasions by Mr. Mkrtchan and or Mr. Taruta, acting at all material times on behalf of Azitio and Dargamo, respectively, during the negotiations for the sale of the claimant's interest in the period June to December 2009. So the allegation is that a representation was made as to the matching price being paid to the Gaiduk seller and the price being paid by the Russian buyer. And it's the price paid to the claimant for its 33.84% participation interest is how the Gaiduk parties describe the sum of money, which we will then see on the next page, page 368, paragraph 10, on 18th December 2009, acting in reliance upon the price representation and the asset representations, the claimant entered into a written agreement by which it agreed to sell Castle Rose, and thus its 33.84% interest in IUD to Azitio and Dargamo for 950 million, the agreement. And then paragraph 11 we can pass over. Paragraph 12. The price of 950 million was calculated on the basis that it represented 750 million for the claimant's 33.84% interest in IUD. So it is the Gaiduk party's own case that that payment, the 750 million, was the payment for the IUD shares. That is their pleaded claim. Plus 200 million for various other assets that were owned indirectly by Mr. Gaiduk and which were to be transferred to the defendants at the same time, including those that it was said had to be passed on to the Russian buyer, in particular the Yalta Hotel Complex and the Hyatt Hotel. Now that paragraph essentially is the backbone of our claim in unjust enrichment. Paragraph 10 is entirely true, we just saw at the top of the page. The contract says on its face, as we just saw, that the consideration is 950 million. But it is the case that the Gaiduk party's own claim was predicated on the assertion, which, as we will see, was common ground, that only the 750 million represented payment for the shares in IUD, and 200 million was paid for other assets. So that is the pleaded context. We can just then move on quickly over the page, para 17, bottom of page 369. The claimant's loss falls to be measured by a reference to the difference between the price for which it sold the 33.84% stake in IUD and its true value as at the 18th of December, the claimant will say that it's entitled to rely upon the price per share that the Russian buyer paid for the 50% stake plus 2 shares as evidence of that value. The claimant understands that the price paid by the Russian buyer was approximately 2.7 billion. It follows that the true value of the 33.84% stake was approximately 1.82 billion, and the loss to the claimant is approximately 1.07 billion, being 1.82 billion less the 750 million paid for the shares in IUD. So the allegation of deceit was expressly made on the basis that the parties were agreed that only the 750 million was a payment for the shares in IUD and 200 million was payment towards the transfer of other assets, and the quantification of the claim was expressly on that basis. The defence is at tab 15, and whilst it is the case that the Taruta parties denied that a misrepresentation was made, it was common ground that the allocation of the price of 950 million was indeed split, as the Gaiduk parties alleged. And if we pick the pleading up at page 395, paragraph 17, the shareholders' negotiations culminated in their together agreeing on or by 18th December on their own behalf and on behalf of their respective vehicle companies to vary and or supplement, you will have seen reference to various memoranda of understanding, so that, 17.1, they would enter or cause or procure their respective vehicle companies to enter into the proposed SPA by which the Gaiduk parties would sell and the Mkrtchan parties and Taruta parties would in equal shares purchase the Gaiduk parties' interest in IUD, together with a number of other assets that we don't need to worry about in 17.11 to 17.17, which are the included assets. But relevantly for the claim, for the appeal in this court, over the page at 17.2, the Gaiduk parties would sell or would cause or procure the sale of, and the Mkrtchan parties and the Taruta parties would in equal shares purchase or cause or procure the purchase of the interests held by the Gaiduk parties in the following entities at the following prices, the consideration for which it was agreed could also be, and in the event was, included in the total amount payable to the Gaiduk parties under the proposed SPA, along with 15 million for an interest of one other party, which we needn't worry about. But the price included 17.2.1, 150 million for NET, the owner of the Hyatt Hotel, and 15 million for Agro Holding, for the Gaiduk party's interest in NET and Agro Holding. If we then go over to paragraph 18, the contract described in the last preceding paragraph, referred to herein as the 2009 Shareholders Agreement, is contained in and or evidenced by a document which was referred to at trial and in these pleadings and at the trial as the 2009 MOU Amendment, and 8.2, the Castle Rose SPA. And then 18.31 is the important paragraph for the purposes of the appeal. It's part performance by the shareholders and or their respective vehicle companies, including 18.3.1, the payment by the Mkrtchan parties and the Taruta parties, 2, and the receipt and acceptance by the Gaiduk parties of the consideration of 475 million each, totaling 950 million, referable as to 750 million to the Castle Rose interest and the included assets, 19 million to the net debt, which we needn't worry about. As to the balance, to the additional assets, and the additional assets I should have picked up is a defined term, namely the assets pleaded in paragraph 17.2, which we just saw. That's
Is it
NEC.
right that we don't need to worry about the net debt of 19
Yeah,
million if
we
we're trying
don't.
to work out the figures?
Well, absolutely you don't. You will be delighted to hear. So the only other paragraph I just wanted to draw your attention to is on page 412. Just to sort of cut it short, you will have gathered that the Taruta parties put their claim in relation to those additional assets either on the basis that there was actually a contract, a binding contract for their transfer, or if there wasn't, for restitution. And it's the restitution bit that is relevant for today's purposes, because we lost at trial on the question of whether there was a binding contract for the transfer of the additional assets. So it's only the claim in restitution that is being pursued in front of you, and that was pleaded, as I say, at page 412, towards the bottom of the page, paragraph headed E, restitution. Further or alternatively, the consideration for and/or the basis of the Taruta parties' payments of 75 million in respect of NET and 7.5 million in respect of Agro Holding has totally failed. And the Gaiduk parties, who have thereby been unjustly enriched at the Taruta parties' expense, are liable to make restitution of the sum paid. Now, in response to that, the Gaiduk parties denied that there was a contract for the transfer of the additional assets, but they continued with the common ground, namely that the price that was agreed and paid for their interest in IUD was 750 million. And we'll just look very quickly at their reply and defence to counterclaim, which is tab 16. And if we go straight there to page 436, we look at 13.2 in the middle of 436. The Gaiduk parties say, it is further admitted that by December 2009, Mr Gaiduk, Mr Mkrtchan and Mr Taruta had reached an understanding. I emphasise those as the individuals because, of course, the Castle Rose share purchase agreement is an agreement between corporate entities. The understanding on the basis of which the price is agreed is in fact an understanding between the three principals. And the fact that it's an agreement that is not made by the contracting counterparties to the Castle Rose SPA will be relevant when we get on to the legal analysis, which is just why I wanted to emphasise the fact that the understanding that is pleaded here by the Gaiduk parties is one between the three principals, not between their corporate vehicles. And the understanding was that the claimant, Avonwick, would sell its stake in IUD to the defendants for a price of 750 million. 2, we don't need to worry about. 3, the interests owned directly or indirectly by Mr and Mrs Gaiduk in the assets listed in 17.2, which is the one we just looked at, that is NET and Agro Holding, would also be transferred to the defendants. Would also be transferred to the defendants, with the value of those assets, plus 15 million as set out in 12.4 in respect of expenses, which we don't need to worry about, to be reflected in the additional sum of 181 million to be paid to the claimant under the agreement for the sale and purchase of the stake in IUD. So we are all agreed that on the face of the contract between Avonwick, Dargamo and Azitio, there is a price that is named, a contractual payment that is due of 950. But it is the case that everyone agreed that the three principals had agreed that of that 950 million, the price for the shares in IUD was actually 750 million.
How do you, just help me on the maths, how do you get to the 950 on the basis of what's pleaded here?
Because, well, a 950 is the contractual price.
Yeah, absolutely.
Exactly how one gets back from the 181 plus the 15 and 2, does that get you there?
None of it to me adds up.
No, it doesn't quite. Figures are then also clarified in, if we just go over to page 438, 15.3. As to paragraph 18.3.1, it is admitted that the first and second defendants paid the 950 million to the claimant pursuant to the SPA. That amount represented 750 million.
That's clear, but it's the 200 I'm interested in.
Yes. Well, the 200 certainly gets you back up to 950,
Yes.
and it is common ground that of that, I mean, there were other bits and pieces.
There were lots of other bits and pieces.
But it's the two numbers that I think are agreed are the 150 million for NET and the 15 million for Agro Holding, and we'll see that if not from the face of the pleading, then certainly from the evidence which Mr. Gaiduk actually gave at trial. But the important point for the purposes of the legal argument is that the pleaded claim, on the pleaded claim of both sides, in fact, as we will see, all three parties, because we'll look at the Mkrtchan pleading in a moment, it was agreed that the price paid for the IUD shares was in fact 750 million. If we then just finally look at page 451, paragraph 58 is the pleaded response to the restitution claim. And you'll see that the claim in restitution is denied without prejudice. The generality, if there were any claim, it would fall to be governed by Ukrainian law. It said that the matters pleaded don't give rise to a valid claim in Ukrainian law. In any event, is denied that the consideration for the payment made to the claimant pursuant to the SPA has totally failed, because the defendants received the claimant's shares in Counsel Rose and or the interests in UGMK and Transport Holding, and 50% of the interests in NET and Agro Holdings were transferred to the first defendant, that's Mr. Mkrtchan, and the division of those interests between the defendant is not a matter with which the claimant is concerned. Second and fourth defendants, that's Mr. Taruta, my client, and Dargamo, were given the opportunity to have the shares in NET and our Agro Holding transferred to them or to entities in their control, and refused or failed to make the necessary arrangements and or pay the technical consideration therefore. Again, we can get to the law in due course, but for the purposes of the agreed facts, it is the case that the 950 million was paid, the shares in IUD were transferred, but Mr. Gaiduk's interest in NET and Agro Holding, for whatever reason, was not transferred to Mr. Taruta or Mr. Taruta's corporate vehicles.
That they were transferred to Mr. M, as I
Mr. Mkrtchan, yes. He certainly got, yes, certain interests were indeed transferred to him, and there were fringe claims by Mr. Taruta against Mr. Mkrtchan in relation to that, again, which you're not concerned with.
Just tiny point of detail while it's in my head. When Mr. Mkrtchan was negotiating for and ultimately got the net interest, he had to pay an additional $13.4 million. Is that right?
There is, yes, there is this concept of technical consideration.
Yeah, so
under Ukrainian.
And it was very small when Mr. Taruta
Yes.
was looking at it, but somehow Mr. Mkrtchan's $13.4 million is hardly a.
That is not nominal. No, I agree with that.
So there was a further negotiation in relation to Mr. Mkrtchan's subsequent transfer.
Yes, that
And
would
he
seem
was happy to pay that extra sum.
for whatever reason.
Right.
Yes.
Thank you.
And that's the reference at the end of 58.3 to the
Yes.
technical consideration, which
Yes.
Mr Taruta did not pay.
It did not wish to pay without an assurance that it was going to come back to him, because he'd already paid on his version and he understood the Gaiduk Parties version of events. As I say, we will be submitting, and I don't think it can sensibly be disputed, that, that as a matter of law, the reason why the anticipated transfers in relation to NET and Agro Holding did not complete is an irrelevance for the purposes of unjust enrichment. The fact is that a payment has been made in anticipation of a binding transfer agreement which has not been completed. If we can then just look very briefly at the Mkrtchan Parties pleading, which is in the other bundle. We're in the core at the moment. We just need to look briefly at the supplemental bundle. At tab 11. And if we can go to page 337, we've just got relevant extracts of this, so we don't get the whole thing. At the very bottom of page 337, paragraph 20, and again responding to the relevant parts of my client's defence, which we saw, paragraphs 17 to 19 are denied, save that it is admitted that, over the page, on 18 December, Avonwick entered into a deed with Azitio and Dargamo for the sale and purchase of the share capital of Karlsruhe for the sum of 950 million. This consideration included consideration for the assets identified in the 18th December 2009 draft document headed Agreement on Making Amendments to Memoranda, as particularised in, as at paragraphs 17.1 and 17.2. 17.2 of our defence and counterclaim, you will remember, is the paragraph that pleads NET and Agro Holdings. So it is also the Mkrtchan's pleaded case at trial that the consideration stated on the face of the Karlsruhe's SPA included consideration, that's the Mkrtchan Party's word, consideration for NET and Agro Holding. Now, that is the evidence that Mr Gaiduk gave at trial. And again, we have been restrained in our illustration of this. There are other examples we could have put in front of you from the cross-examination. But if we just look at a couple of very short extracts from the evidence, first of all from Mr Petrov, who was called on behalf of Mr Gaiduk, and that is still in the supplemental bundle at tab 7. Oh, sorry, witness statements first, not cross-examination. Witness statements first. Petrov 1, supplemental bundle at tab 7. Page 86 is where it starts. Page 122 is where it gets particularly relevant. And you'll see 3/4 of the way down page 122, there's a heading, the Karlsruhe's SPA. So that's the part of the story that he's reached at this point. And if we just go forward in that section, I don't want to take you to an unnecessary amount, but if we go to page 124, you'll see paragraph 93. Second, the partners discussed 2 additional assets, which Mr Taruta and Mr Mkrtchan told Mr Gaiduk that the Russian buyer had asked to receive as a condition of the sale going ahead. And the first one, 93.1, is NET. Mr Mkrtchan told Mr Gaiduk that Mr Vladimir Dmitriev, who was then the chairman of VEB, had personally requested the Hyatt Hotel to be included in the sale to the Russian buyer. And then at 93.2, Mr Gaiduk was reluctant to part with the Hyatt Hotel. However, Mr Mkrtchan insisted that it was important to Mr Dmitriev that the Hyatt Hotel was included and it was a condition of the sale going ahead. Mr Mkrtchan said that there was nothing he or Mr Taruta could do about it. He and Mr Taruta emphasised that they were only in the position of having to negotiate with this Russian buyer because Mr Gaiduk wished to exit the business, and in the circumstances Mr Gaiduk should help them by conceding this point. In the end, Mr Gaiduk, brackets, not Avonwick, agreed, Mr Petrol's word, agreed to transfer NET, he says, to the Russian buyer on the basis that the price payable under the SPA would be increased by $150 million. So it is the Gaiduk parties' evidence that there was an agreement by the principals that that price, again their word, was payable in respect of that asset. And if we go over the page, we see the same in relation to Agro Holding. Paragraph 94. Third, the partners discussed the allocation of two of their other joint business interests, which Mr Gaiduk wanted to extract himself from at the earliest opportunity, as follows. And the first one is the one that we're concerned with, Agro Holding. And you'll see 6 lines down, again I won't read the whole thing, but 6 lines down in that paragraph 94.1, the partners agreed in very general terms to value Mr Gaiduk's family stake by applying a multiplier to the company's reported EBITDA in the previous financial year, multiplied by the size of his shareholding. Ultimately, they settled on a value of not 15 million for Mr Gaiduk's family share. And then paragraph 96, at the bottom of the page, he's talking about...
well, 95 is presumably...
Sorry. Yeah, sorry, yes, exactly so.
But you want us to see 96?
96 as well, that just wraps it up. In the usual way, I recorded the outcome of the partners' discussions in an updated memorandum of understanding and circulated it by email on 14th December for the partners' records and reference. And you'll see there's a footnote 52, which lists a whole load of document references. And it mentions that there are a few typos, which were subsequently, over the page, continuing with the footnote, discussed and corrected. The most important is the miscalculation of the price of NET as 152.6 rather than 150 million.
And again, I know I'm being dull about this, but again, the math doesn't work, does it? So if we get 750 plus 150 plus 2...
no, the 150 is part of the 200.
Yes, absolutely.
So
you get. So I'm trying to get between 750 and 950.
Right,
you get 750 plus 150, 93.2, plus 15, 94.1, plus 2, 94.2. You don't get to 950.
Sorry, the 750 is IUD.
Correct.
150
net
is NET, so we're up to 900.
Yep. 15 for agro.
15 for agro.
2 for... I'm not even going to try that one. 17. And then you get...
Sorry, but
up to
sorry, where is the 2?
94.2.
Oh, I see, sorry, yes.
So on that basis, they got to 917. And that's somehow rounded it up.
I'm not going to try to attempt to explain the maths of the various other bits, because the only points that matter are the agreed numbers. The starting point is the 950. The 750 is agreed, because everybody agrees that. And the 15 million for Agro Holdings and the 150 million for NET is all agreed. So whether there were other 1s, 2s, and other incidental payments, it is not. I mean, it is complicated on the maths. I agree. In some aspects of the case, it is messy. But what is important for our purposes is simply the common ground in relation to the 950, the 750, the 150 and the 15. So that's just Mr. Petrov's evidence. Mr. Gaiduk's witness statement is in the same bundle at the next tab, and we can go straight to page 186, where again he picks up the story in November and December. You'll see the heading 11 events in November and December 2009. And we just go over the page to paragraph 130. I did not want the entire sale to collapse, and even though my strong preference was to keep the Hyatt Hotel, I agreed for the inclusion of the Hyatt Hotel in the deal. However, I was not willing to include the Hyatt Hotel for free, particularly since Mr Mkrtchan and Mr Taruta had only recently agreed to the Hyatt set-off, which has been dealt with earlier. I insist...
And is the Hyatt set-off of any relevance to us?
No, it's simply why the Hyatt was back in Mr Gaiduk's hands.
Right.
That was because it was originally jointly owned, and then it ends up with Mr Gaiduk, and then Mr Taruta and Mr Mkrtchan are buying it back. I insisted that if the Russian buyer and or Mr Dmitriev were required that the Hyatt Hotel was included in the sale, they should pay at least 150 million for it, the Hyatt sale price. I would not have included the Hyatt Hotel in the deal had I not been told that it was a condition for the deal to go ahead. So he is making multiple admissions there which support our unjust enrichment claim, namely that 150 million was attributable to the Hyatt Hotel.
Well, at least 150 million.
So, yes, at least 150 million for the Hyatt Hotel. And that it was on that basis that the Hyatt Hotel was included in what he calls the deal. Now, we all agree that the Hyatt Hotel is not mentioned in the Castle Rose SPA. So the deal that Mr Gaiduk is there talking about in his witness statement is the deal that's made between the principals, which represents, when we get on to discussing the law of unjust enrichment, the basis for the payment of the additional sum above 750 million for the IUD shares. That's the deal. And it is represented in part by the sale price for the Hyatt interest. And then we go over the page, page 188.
If you're right, what was the obstacle to a claim for rectification?
I have, I presume, well, what would have been the obstacle to a claim for rectification if the court had been satisfied that there was a prior contractually binding agreement, so to speak, in relation to these matters, then a claim, I suppose, could have been pleaded.
It would have been a rectification of an agreement between the corporate vehicles rather than between the principals.
It would have had to been that, yes. And
You say that there's a broader agreement, not in itself contractually enforceable as the judge found, but you say the basis for the additional payment.
Yes, exactly so. And just to complete the evidence, page 188, heading at the top of the page, other sums payable as part of the deal. Again, it's important to see the words that Mr Gaiduk himself uses. And paragraph 134, just over halfway down the page, the $750 million purchase price was only for Elena's 33.08% interest in ISE. Elena is his wife, and beneficially his position was that the assets owned by the Gaiduk parties through various corporate vehicles were beneficially owned by her rather than by him. We don't have to worry about that. Collectively, with the Gaiduk parties, what matters is, again, very clear language, first of all with precision as to the amount and the description of that amount, 750 million, as being the purchase price for the IUD shares. And then finally, over the page 189, paragraph 137, Mr Mkrtchan and Mr Taruta agreed to buy Elena's stake in Agro Holding. And again, important to identify the parties, Mr Mkrtchan and Mr Taruta, not Dargamo and Azitio. And they agreed to buy the stake in Agro Holding. Initially, I had proposed that I would buy out Mr Mkrtchan and Mr Taruta's interest. They didn't wish to sell their stakes, and I decided to sell Elena's stake to them instead. We provisionally settled on a valuation of 15 million for Elena's stake, Agro Holding sale price.
But this is against a background that, in fact, the dealings between these parties are always between principals or their representatives, and that transactions nevertheless take place through their holding companies of one kind or another.
Absolutely so, yes.
And so I just find it difficult, and I'd be interested for some help about why, therefore, it's significant or said to be significant that in a witness statement like this, Mr. Gaiduk is saying, I decided this, I did that, this is Elena's interest, this is whoever's interest, and it all gets rolled up into an agreement which is between vehicles.
The answer to the question is that when we get to look at the law on unjust enrichment, the question of whether something is unjust as a benefit conferred on the defendant, it is going to turn in significant part on the basis upon which a benefit has been conferred.
Absolutely,
And
but I thought the distinction, I'm sorry to interrupt you, I thought the distinction you were trying to make was between the companies and the agreements, the Castle Rose SPA, and the individuals, and you've been showing us very carefully that the deal is between the individuals, and here's the witness statements.
Yes.
And what I'm saying is I'm a little bit confused about that in the context of the fact that I think that the overall context is that these individuals always do business together, but they all do, they make arrangements and negotiations and between themselves or their representatives, and then it's played out in documents which are between corporate vehicles, and that's not very surprising.
No, indeed it is not at all surprising that corporate vehicles are used. I am largely emphasising the fact that the, well, I'm doing two things. One is I'm emphasising what the deal was.
Absolutely, I understand that.
And the second thing I'm doing is emphasising that the deal is agreed between the principals in order to anticipate some legal argument we'll come to later, because one of my learned friend's arguments on the law, don't want to get into it too much now, but one of his arguments on the law is that where you do have a contract, as we do with the Castle Rose SPA, he is saying that unjust enrichment should not be allowed to operate so as to cut across the contractual allocation of risk, as he puts it.
Yes.
Which means it's an elaborate way of saying that the contract says what it says. The contract says 950 million for the shares in Castle Rose.
And perhaps I'm being a little bit too oblique, but my problem is that looking at witness statements in which Mr. Gaiduk or anyone else says, I did X and I did Y, it is one thing, but to extrapolate from that to there was a separate deal which had a separate life is rather difficult when those individuals always, it would seem, in context, behave in this way and then conduct their business actually through the corporate vehicle. That's all I'm saying.
No, I'm very grateful. And to say there was a separate deal, if by that one is positing a binding contract, we've already lost on that. One of the issues...
And understanding, I think is what you're saying.
So yes, but we do say that the deal, in the sense of the basis upon which payment was made through vehicles, the basis was agreed between the individuals. Avonwick and Dargamo and Azitio's directors don't feature in these discussions. The basis upon which payments are made is agreed between the principals. So,
I'm sorry, Mr. Crowe, I've held you up
no,
too long.
not at all. It's obviously helpful to well, I hope it's helpful to try answering your questions. I'm not
So
sure.
you say for these purposes, the individuals and the corporate vehicles are indistinguishable?
For the purpose of identifying the basis upon which a contractual arrangement was entered into, it is important to identify what factually was agreed between the relevant principals. I don't say it is necessarily irrelevant that corporate vehicles are then ultimately used, because in a sense, that again, I don't want to anticipate too much of the legal argument, but it is the fact that Avonwick, Dargamo and Azitio are the contracting counterparties, but the basis upon which they enter into that contract has been agreed by others. So I'm not suggesting you ignore the separate existence, but in order to assess the true basis upon which the bargain is made, you need to look at the principles rather than just the face of the contract.
And I think it was, I understood or discerned that actually really what you were saying also was the deal between the individuals is outside the four corners of the contract.
Yes, exactly so. Exactly so. And that in a sense, is the whole of our legal argument.
Yeah.
I mean, essentially, although it's put in a number of different ways, the whole answer to our claim in unjust enrichment, both in the judgment and in Malone and Friends' argument, is really different ways of saying the contract says what the contract says. And the question is whether we can satisfy you that there is an injustice in allowing the Gaiduk parties to keep the 150, well, my client's share of the 150 million for NET and my client's share of the 15 million for Agro Holding, when it was agreed between the principals that those elements of the consideration were included in the contract for those assets, and those assets have not been transferred.
No, not that they were included in the contract.
Well, sorry,
The contrary, they clearly weren't.
no, sorry, they were included in the deal. The price referable to those assets is then reflected in the additional price.
Yeah, so that in addition to performance, assuming the option was exercised, of the contractual obligations and the transfer of the assets for which the price was payable, additional assets not mentioned in the contract would be transferred for no additional consideration.
Exactly. Would be being the words used here. Just pausing there, we're looking here at witness evidence. One of Malone and Friends' submissions, and I might as well I'll answer it now, one of Malone and Friends' submissions is that this is all just inadmissible evidence of subjective intention. With respect, it isn't, because the questions we'll see when we look at the law on unjust enrichment is to identify the basis upon which a benefit is conferred by the claimant on the defendant. This is not a case where my client harboured some sort of subjective, uncommunicated thought or motive. This evidence is evidence of what was the common ground, what was the deal.
A shared and agreed understanding.
Exactly.
But we nevertheless, I mean, when you come to the law, we have to consider to what extent one is able to look outside the contract under which the price was paid.
Exactly. That would be the task. I just wanted to set the factual context firmly before getting to that. I don't know if we were just to finish with Mr. Gaiduk's witness statement, page 191. Paragraph 146, sorry, we're at tab...
I'm so sorry, I've shut my file, so
And
could you
it
tell me?
hasn't got away from it.
Resume.
So it was tab 8 in the supplemental bundle, page 191, paragraph 146. The amount payable by Dargamo and Azitio under the Castle Rose SPA was 950 million, because it was prepared simply and quickly, the Karlsruhe SPA itself did not set out that the Karlsruhe purchase price was calculated as follows: 750 million for the Karlsruhe interest, not including the Dubyna interest, that was a very small other party. B, 200 million for a number of things, including little 4, the Agro Holding sale price, and the Hyatt sale price. Now, those capitalised terms are referring back. Yeah, exactly. The 150 and the 15 million. The total compensation for these items, in fact, totals, here we go, at 201, but Mr Mkrtchan, Mr Taruta and I agreed that this should be rounded down to 200 million. And then finally, we just look, I don't think that's enough on that witness statement. That is, if we can just keep that bundle, that is how the case was opened at trial. If we see at tab 10 in this same bundle, the written opening on behalf of the Gaiduk parties, we just go over to page 322, paragraph 18. Counsel for the Gaiduk parties is saying, by an agreement signed on 18th December, Avonwick then sold its 33.84% stake in IUD to Azitio and Dargamo for 950 million. It is common ground that by an agreement dated 30th December, Azitio and Dargamo sold 50% plus 2 share stake in IUD to the Russian buyer for 2.7 billion. Completion under the 2 agreements happened on the very same day. There is an obvious and very startling disparity between the prices paid under the 2 transactions, which meant that while Avonwick received 750 million in return for giving up a 33.08% stake in IUD, Azitio and Dargamo received very significantly more. You can see the rest of that paragraph. So again, it's absolutely clear, it is inevitable that the case was presented on the basis of the pleading and the witness statement. If we just also look very briefly at page 327, paragraph 28A, it is common ground. At the same time as the sale of IUD was being discussed, the parties were also discussing the transfer between them of various other shareholdings and payments of other debts. Amongst the matters discussed at the time, it is common ground that the parties intended that shares held by the Gaiduk parties in 4 companies, and that includes Agro Holding and NET, would be transferred to the Mkrtchan and Taruta parties. Over the page at the top B, the total sum paid by Azitio and Dargamo for the IUD shares under the Karlsruhe SPA was 950 million. It is common ground on the pleadings, certainly at least between Mkrtchan and Gaiduk parties, that sum was calculated by reference to 750 million in respect of IUD, approximately 150 that was intended to represent the value of the shares in NET, approximately 15 that was intended to represent the value of the shares in Agro Holding. And then over the page 329, E, it's common ground, no share purchase agreements were ever concluded between the relevant entities owned by each of the Gaiduk parties and the Taruta parties in respect of DBP and NET. And in little Roman 2, there was a contract in relation to Agro Holding, but there was a demand for the technical consideration, and that deal never completed. So that was how the case was opened, and the evidence that was given, finally, just very briefly, still in the same bundle, tab 12, we have Mr Gaiduk on day 3, tab 12, page 344 of the bundle. You'll see Mr Gaiduk being cross-examined, and
this is all presumably through interpreters.
Yes, I'm pretty sure. Yes, it was. It was, because there are some translation issues that one sees. Not that they matter for this.
I mean, he explained in his witness statement that he didn't.
Yeah.
Cope.
Yeah, but That's right. Page 344, page 12 of the transcript, so the bottom right-hand page, on that page, at line 4, good morning. December 2009, Avonwick received 15 million from Mr Taruta and Mr Mkrtchan on account of Mr Dubyna's interest in IUD, didn't it? Yes, this is true. But you didn't pay that 15 million to Mr Dubyna, did you? Mr Dubyna got shares in Hyatt, in the asset called Hyatt. That's right. You didn't pay him the 15 million cash, but you transferred 24.5% of the company NET to him in 2012. This is true. But, this is the relevant question and answer, but in December 2009, Mr Taruta and Mr Mkrtchan had paid you 150 million for 100% of NET, hadn't they? Yes, this is true. And then Mr Foxton asked whether that was honest behaviour, and Mr Gaiduk asked him to specify what he meant by that. So there is a clear admission there that 150 million was paid for the interest in NET. And then if we go to tab 13, we'll see it's still Mr Gaiduk in cross-examination, and again on the right-hand side, at the top of the page, you'll see Mr Gaiduk is being taken to the Memoranda of Understanding. Just to pick out the relevant exchange, the page 4 of the transcript on that page, line 7. Looking at the MOU, he says, look at to clause 9, for example, the figure there of 15 million for agro holding was a figure you had agreed with your partners, wasn't it? Yes, my lord, that is true. So that is the case. And then if we can just also go over the page 347, picking it up at the very bottom left-hand corner on page 347, line 18 of page 6 of the transcript. Mr Gaiduk, you see on the second page there is some handwriting. Yes, I can see that. You recognise whose handwriting it is. I believe it's Mr Taruta's handwriting. Can you see in clause 10, underneath the figure of 953.6, there is a handwritten figure 950? Yes, I do. I suggest, if you want to cross-refer, I won't take you to it, but if you want to cross-refer, the document on which he was being cross-examined, if you want to see it, is in this bundle at tab 3, where you will see that manuscript. The question then is at the top of the next page. I suggest what happened is that at this meeting in Kiev, the three of you agreed that the figure that would go into the Castle Rose SPA would be rounded to 950 million. Yes, we agreed that. Of that 950 million, 750 million was in respect of the interest in IUD, wasn't it? To my shares, to my interest in IUD, yes. And I suggest that the terms we see recorded in this document, with the adjustment to 950 million, represented the final agreement you had reached with your partners. Yes, that's true. And then finally, over the page, 348.
I don't know whether it's of any relevance whatsoever. I'm on page 347, page 7 of the transcript. You've taken us to the 950 million and 750 million.
Yeah.
And then line 7. And then if one goes on, there's reference to the Castle Rose SPA.
Yeah.
And at line 18, I suggest you'd agreed with Mr M and Mr Taruta that the agreement would be, in relation to the transfer of the other assets, would be governed by English law, and the answer is that's not the case.
Yes.
And then I just wondered that whether there's any relevance in relation to that, and that it was being therefore suggested by Mr Gaiduk that the transfer of the other assets was to be governed by another law.
The question of the applicable law in relation to the transfer of the other assets is dealt with in the judgment in the court below, and I'll very briefly take you to that. And the argument that was run is that because the inclusion of the extra 200 million in the Castle Rose SPA brought that element of the consideration into a written contract, the Castle Rose SPA, which was itself governed by English law, that therefore the claim in contract for the additional assets was also governed by English law, either by express agreement or by implied agreement, and the judge rejected that. He said the parties did not, and presumably partly on the basis of this kind of answer, that on the evidence there wasn't an agreement that the dealings in relation to the additional assets would be governed by English law. And one of the reasons the judge actually reached that conclusion is that, I think it's paragraph 513 in the judgment below, is that the judge points out that the Castle Rose SPA is an agreement specifically choosing English law made between Avonwick, Dargamo and Azitio, whereas the understanding in relation to the additional assets is an understanding between Mr Taruta, Mr Mkrtchan and Mr Gaiduk personally. So
that's why I thought you might be interested in those lines, that's all.
I'm grateful, thank you. And then finally, if we can just look very briefly at the very bottom of page 348, last two lines on the bottom right-hand corner, Mr Foxton is saying, so you're saying there's no meeting, i.e. Mr Gaiduk, in which you and Mr Taruta discussed the payment of Agro Holding dividends. So the discussion here is about dividends after, in fact, the 2009 agreements have completed. There was, just pausing and stepping back, I don't want to get into too much of the fringe detail, but there was quite a long period between sort of 2009 and 2012 when some assets were transferred and negotiations were being had for completion. And there was some discussion about what should be happening with dividend payments in relation to companies which it was anticipated would be being transferred, which was the context in which these questions are being asked. Obviously the implication that my clients, then counsel, was seeking to draw is that if there were discussions after December 2009 under which dividends in relation to Agro Holdings should have been being paid to Mr Taruta, that would be evidence that there was an agreement that the interest in Agro Holding would be transferred to Mr Taruta.
And that's what you get to at the bottom of page 41 of the transcript.
Exactly. That's where we get. Exactly. So if you just pick it up at line 13, because we're in a state of transfer, we need to transfer an interest in Agro Holding to Mr Taruta. That was Mr Gaiduk's answer to the question why it was that dividends received by your wife should be paid in Mr Taruta's favour. And then in April we signed an agreement according to which Mrs Gaiduk were to sell that interest to Mr Taruta with a contingent value of $370,000, I think. So this is a technical payment. The technical payment didn't go through. The question was suspended. There's a reason we didn't participate in the shareholder meeting in distribution of dividends. All of that was done without us questioning. Can I suggest that the reason that your representative, Mr Petrov, recognised that the dividends your wife had received should be in Mr Taruta's favour is because Mr Taruta had paid you $7.5 million for this asset back in December 2009. My lord, we're not denying this. I did not deny this. So we have there, as I say, the evidence very clearly supporting the pleaded claim in relation to the $750 million for the shares in IUD, $150 million for the interest in NET, and $15 million for the interest in Agro Holding. Can we then just look at the judgment, and you will have seen this, so I don't want to spend too long on it, but it may be just useful to walk through a few paragraphs, partly also just to remind you of the structure and the sequence in which the issues were decided. So it's in the core bundle at tab 9. And if we can, you will no doubt have seen the contents page, which identifies where all the various issues are addressed. If we can go to page 137, which is in the introductory sort of overview section, where the judge is just giving a very high-level summary. Paragraph 52, he says, final negotiations regarding the detail of the agreement for the sale of Mr Gaiduk's interest in IUD took place in early December 2009. On the 15th of December, the directors of the partners' corporate vehicles, Avonwick, Azitio and Dargamo, approved the transaction and granted powers of attorney to the relevant partners to enter into it on their behalves. The final version of the Gaiduk sale was a deed signed on the 18th of December, the Karlsruhe's SPA, which gave Azitio and Dargamo the right to acquire Avonwick's shares in Karlsruhe's for 950 million. Although not clear from the face of the Karlsruhe's SPA, it is common ground that the 950 million price was intended to include Mr Gaiduk's interest in a number of assets, including the Hyatt Hotel, UGM Key we're not concerned with, Agro Holding, and DPP, which we're not concerned with. Mr Taruta's case is that an agreement was reached, reflected in the Karlsruhe's SPA, as well as in certain other exchanges, the alleged 2009 shareholders agreement, pursuant to which Mr Gaiduk was required to transfer to Mr Taruta and Mr Mkrtchan his interest in those assets. So he's identifying there the claim, the anterior claim, so to speak, which is now not being pursued because it failed at trial, that there was a contract, a binding contract in relation to those additional assets. And if we can then just turn over briefly page 139. Paragraph 58, still in the same brief overview, his lordship says, thirdly, thereafter, in 2011, the partners took steps to give effect to the common understanding that Mr Gaiduk would arrange to transfer his interests in ... NET and Agro Holding to Mr Taruta and Mr Mkrtchan in equal shares. So that gives you the brief intro. We can then pick up the judgment. You'll see that the next many pages deal with witnesses and then the Avonwick claim against Mr Taruta and Mr Mkrtchan in deceit, which fails. And if we can go straight to page 223, you'll see, just for the sake of it, the conclusion on the Gaiduk party's claim in deceit is at page 464, and that claim fails. And then you'll see the main heading, the Taruta claims against the Gaiduk parties and the Mkrtchan parties. And just to pick up a few elements of that, we've got applicable law is the first heading, and we don't need to dwell on the reasoning there, but if we just go straight through to page 231, you'll see the point at the very bottom of that page, the point that I made to my lady a moment ago, paragraph 513. Secondly, Mr Foxton QC's reliance, that is still dealing with applicable law, in relation to the claim that there's a contract for the transfer of the additional assets. Mr Foxton QC's reliance on the fact that the Karlsruhe's SPA contains an express English choice of law clause provision does not assist in circumstances where that was an agreement between Avonwick, Dargamo and Azitio, and so an agreement to which Mr Gaiduk, Mr Mkrtchan and Mr Taruta, the alleged parties to the alleged 2009 shareholders agreement, were not themselves parties. It follows that the express choice of law in the Karlsruhe's SPA was not an express choice of law made by the parties to the alleged 2009 shareholders agreement. The fact that the parties to the Karlsruhe's SPA were closely associated with these individuals is, as a matter of analysis, neither here nor there. So the judge is there making a distinction between the corporate entities which enter into the contract and the principals who were said to be parties to a binding contract.
But that distinction was being made in the context of the alleged 2009 shareholders agreement.
Exactly. Specifically in the context of applicable law. And then just to pick up the conclusion there, so page 234, very bottom of the page, paragraph 530, the conclusion is that insofar as there is a contractual claim for the transfer of these additional assets, the judge reaches the conclusion that Ukrainian law would apply to that contractual claim. Then, on that basis, we just go over the page 235. His Lordship then considers the law on formation of contracts. Under Ukrainian law, we don't need to pause on that because the contractual claim failed and we're not appealing about that. But then just to follow the structure of the judgment, page 241, you'll see in the middle of the page is the section where His Lordship deals with the question whether there was a valid and binding contract in relation to the transfer of these additional assets. That then occupies a considerable amount of the next many pages. And just to pick up why he says there wasn't a binding contract, if we can just jump forward to page 270. You'll see he's been quoting a number of the documents on which my clients relied at trial, and you'll see, picking it up at paragraph 668 onwards, he discusses those documents and he says it's impossible to conclude based on this wording either this itself was a valid and binding agreement or that such an agreement had already been concluded at the meeting on the 13th of December. And various other points are made. I don't want to read them out, but the accumulation of reasons why there wasn't a contract is discussed in paragraph 670 to 675. But for the purpose of the unjust enrichment claim, it is important to pick up the judgment at 676. So although this appears in the part of the judgment dealing with the question whether there was a binding contract in relation to the transfer of these additional assets, it is important to see what the judge made of the pleaded position and the evidential issues. So picking up 676, notwithstanding these difficulties, Mr Foxton went on to submit that, consistent with his position that the Castle Rose SPA was part and parcel of what had been agreed on 13th of December, the 950 million consideration inserted into the Memorandum of Understanding was later inserted into the Castle Rose SPA on the 17th of December, as he pointed out. As with the July Castle Rose SPA, the December SPA provides no indication of the assets other than IUD, which Mr Gaiduk had agreed to transfer. The payment price had increased significantly from the 723.75, which you saw in the July agreement, which I took you to at the very beginning, to which reference was made, as Mr Foxton submitted. The price of 950 million was calculated on the basis that it represented 750 million for the claimant's 33.84% interest in IUD, plus 200 million for various other assets that were owned indirectly by Mr Gaiduk and which were to be transferred to the defendants at the same time. This was not in dispute. Indeed, the terms of the document acknowledge it to be the position expressly. Nor is it in dispute, therefore, that the Mkrtchan parties and Taruta parties used the Castle Rose SPA to pay the Gaiduk parties money, which was intended to be applied against the transfer of the additional assets.
Can I just check from my note that the reference there to the document is the draft of MOU 4 dated the 18th of December?
Yes. He then says in 678 that he doesn't consider that that means that it should be concluded that parties entered into a binding agreement on the 13th of December as recorded, if not contained in MOU 4, nor do I consider that it means that, as Mr Foxton put it in closing, that the Taruta parties start sort of 30 love up. I am clear, on the contrary, the fact of the payment having been made is of only limited significance to the question of whether there was an agreement concluded, as alleged by the Taruta parties. I agree with Mr Wolfson that the basis on which these sums were transferred under the Castle Rose SPA was that they represented an advance from Mr Taruta and Mr Mkrtchan to Mr Gaiduk, made in the expectation that the parties would reach legally binding agreements against which those sums would be offset using offshore structures. And on our submission, when you come to working out whether or not there is unjust enrichment in this case, paragraph 679 provides the answer. That was the agreed basis on which those payments were made. It's not what the contract says. So if you choose to decide this case purely by reference to the words on the page in the contract, I lose. But when you're applying the test of unjust enrichment in our submission, the court should be looking at what the true basis of the benefit conferred on the Gaiduk parties actually was, and the judge has made that finding. And it's significant in the very next paragraph how he expresses it. On any view, and in any event, the payment of the additional sum under the Karlsruhe SPA, the additional sum is the extra 200 million, cannot be said to be consistent only with the existence of the alleged 2009 shareholders' agreement. As such, it is not evidence which assists the Taruta Parties' case. It doesn't assist the Taruta Parties' case that there was a binding contract, is what he means. Again, as Mr Wilson QC put it, in his case displaying more of an agricultural bent than a sporting one, reliance on the payment having been made is to put the cart before the horse since. And again, this is critical. If there was a separate 2009 shareholders agreement, i.e. a contract, between the partners, then the payment could constitute performance of that agreement. If there was no shareholders agreement, then the payment would amount to a deposit or advance made in hope of future agreements. Now, what he is saying there, he is saying in the context of having to decide whether there was a binding contract. And he's saying that merely paying money, the 200 million additional sum, doesn't prove there was a contract, because it was entirely consistent either with there being a contract and that being contractual consideration paying, or with the anticipation that future contracts would be entered into. But with the greatest respect, what in our submission the judge then does is overlook that finding once he has decided that there was no 2009 shareholders agreement, meaning there was no binding contract for the transfer of these additional assets. He then overlooks the fact that he has already said twice in 679 and 680 that in the absence of a binding contract in relation to those assets, the payment of the additional sum must represent the payment of a deposit or advance made in hope of future agreements. Again, my learned friend's only answer is, well, that's not what the contract says. We know it's not what the contract says, but it is why the payment was made. And it's what the judge found as to the reason why the payment was made. So if we then go on, page 276, just to draw things together, you'll see at paragraph 696, the judge says, drawing together these various evidential threads, I've reached the clear conclusion that the Taruta Parties have not established the existence of the alleged 2009 shareholders agreement, whether applying Ukrainian law or in the alternative having regard to English law principles. We can then move straight on to page 291, where he does deal with the unjust enrichment claim. And he starts by considering the applicable law, and we don't need to spend any time analysing that because that's not now in dispute. So if we just turn over to page 293, you'll see at paragraph 776 that the conclusion on applicable law is that English law would apply, to the unjust enrichment claim, and there is no dispute about that. And then from paragraph 777 onwards to paragraph 799, his lordship discusses an issue which he says is obiter. You'll see, and the issue he is discussing is whether a claim in unjust enrichment can be made in circumstances where there is a contract between the parties. Now, what he is in fact talking about is where there is, contrary to his finding, a 2009 shareholders agreement. So what he is discussing between paragraphs 777 and 799, he says he's obiter dicta. You see that in paragraph 779. In deference to the submissions which were made, and albeit on the basis that what follows inevitably amounts to obiter dicta, I propose to explore the issue relatively briefly. So he is exploring, just to be clear, he is exploring the issue whether a claim in unjust enrichment can be sustained in circumstances where there is a valid and subsisting contract between the parties. Now, on the face of it, what he is discussing is what, in his judgment, is a hypothetical question because he has found that there wasn't a 2009 shareholders agreement. But I think it is actually common ground between my learned friend and I that the legal principles he discusses remain relevant because there was a contract between the parties, namely the Karlsruhe SPA. Yeah. So although he says that what follows is inevitably obiter dicta, it is, in our submission, and I think it's common ground, my learned friend is nodding, it is common ground that the logic of what he is saying here is a relevant part of his reasoning, because a very significant part of my learned friend's answer to our claim in unjust enrichment is there was a contract, it's the Karlsruhe SPA. You can't have a claim in unjust enrichment which cuts across the contractual consideration as stated on the face of that document. So I'm not now then going to read the whole of that, but I just wanted to make clear that although the judge says what he is discussing is obiter dicta, I think we both agree that the whole of, as I say, it's 777 to 799 is where he is discussing those principles, and you'll see that he picks up towards right at the end with reference to there are two cases that will be spending some time on, Barnes and EastEnders Cash and Carry, and the Australian case of Roxburgh.
I mean, in a way, it is odd when one comes to this to see that he's only looked at these principles in the context of the alleged 2009 agreement, doesn't address the relevant SPA. Yeah. But I suppose it's wrapped up, isn't it, in paragraph 811?
Yeah, to be honest, he does.
If he gets doing shorthand.
No, you're absolutely right.
It's
yeah. No, I think he does get there, although he doesn't sort of quite.
No.
It doesn't quite phase up to it, so to speak. But no, I think we're all agreed that this what is being discussed in 777 to 799 is a relevant part of the reasoning that then, as you say, feeds into his conclusion in the 800s. But it may be just worth, I'm not going to read much, I just wanted to draw your attention to 798 and 799. He says, as to Roxburgh and Barnes, in both of those cases, the claimant was able to recover in unjust enrichment because the basis on which it had performed its obligations had fallen away for reasons outside the control or contemplation of the parties. The present case, by contrast, does not concern an external state of affairs, which has either failed to materialise or, if it did exist, has failed to sustain itself. Rather, it concerns the failure of the parties to perform the part of the contract in respect of which the payment was made. In such circumstances, I can see no principal reason for departing from the orthodox approach. Now, that paragraph only makes sense if he is talking about the 2009 shareholders agreement. Because if he is talking about the Karlsruhe SPA, he could not have talked about the failure of the parties to perform the part of the contract in respect of which the payment was made. The payment for these purposes is the 200 million additional sum. Under the Carcero's SPA, there is no contractual obligation to transfer the additional assets. So the reasoning, and this is one of the problems with the judgment, the reasoning that then infects his later assessment of whether our claim can succeed in the absence of a 2009 shareholders agreement is actually infected because he's already looked at Roxburgh and Barnes, but through the spectacles of whether or not a claim in unjust enrichment could have been sustained, notwithstanding the existence of a 2009 shareholders agreement, which he finds doesn't exist. So I just wanted to emphasise that that is the reasoning that underlies his treatment of those two key authorities, and in our submission it's just not applicable. So he then, after 799, turns to what he says at paragraph 800, to the issue which matters for present purposes, the position where there is no subsisting contract in place. In the present case, the 2009 shareholders agreement, it is not in dispute that, as made clear in Goff and Jones, a claim in unjust enrichment requires a claim to establish that the defendant was enriched, his enrichment was gained at the claimant's expense, and that his enrichment at the claimant's expense was unjust. So that is clearly those are the three elements. There's no dispute about that. The discussion then turns to the various cases which we will address you on, and I don't need to take you through the judgment. It sounds very clearly as if you have already got the reasoning well in mind, but the key paragraphs are really, I think, 808 through to 813. And yes, I'll come on to those as well. But what is clear in our submission is if one looks particularly at 811, 12 and 13, without reading them out to you, what the judge is essentially saying is the contract, the Carcero's SPA, says what it says. And we can't point at the last lines of 813. It was Mr. Calver's submission that the position is different where, as in the present case, given what I have decided concerning alleged 2009 shareholder agreement, the Taruta parties were unable to appoint to another contract in aid of the apportionment exercise. So essentially the judge's reasoning throughout is simply that there is a written contract which on its face stipulates a single contractual price for the shares in Castlereagh, end of story. And one also, it's worth looking over just to see how the judge reasoned his way through it. If we just look very briefly at 818. Mr. Foxton pointed out the fact that MOU 4 recorded that 15 million was payable by the Taruta and the Mkrtchan parties in respect of Agro Holding. On that basis, Mr. Foxton suggested it's perfectly possible for the court to apportion 7.5 million of the total monies paid by the Taruta parties to the acquisition of this interest. Secondly, Mr. Foxton referred to the sums payable for NET, suggesting that it's clear that at least 75 million of the monies transferred by the Taruta parties was in respect of the interest in NET. And then the judge says this: the difficulty with Mr. Foxton's reliance on both of these matters is that they entail reliance on it having been established that the alleged shareholders' agreement was in fact entered into. And that, with respect, is just wrong. We are advancing the unjust enrichment claim on the basis, and this is what he's addressing here, on the basis that there was no 2009 shareholders' agreement, but that it was common ground that 15 million was paid in respect of Agro Holding and 150 million in respect of NET. And to make that point as to what the true basis on which those elements of the consideration were paid, the Taruta parties do not have to show that there was a contractually binding 2009 shareholders agreement. They only have to point to the pleadings the evidence and the submissions which demonstrate that it was common ground that that was the case. So again, there is, with respect, a flaw in the reasoning on which the judge relied in order to reject the claim which was based, as I say, on matters that were common ground. If we just finally look at paragraphs 822 and 823.
In your presentation this morning, you've very helpfully taken us through the paragraphs you flagged up in the pleadings and the evidence and the witness statements. You haven't gone to any of the drafts of MOU4. You've seen what Mr Dubyna has spent quite a lot of time on those drafts. Do you say you don't need to rely on the drafts of MOU4?
I don't think they add significantly to the common ground that emerges from the pleadings and from the and from the witness statements and from the way the case was presented. I mean, I'm not shying away from them because they do have the numbers 15 million, 75 million. So I'm not sort of rowing back from them. It's just that for the purposes of oral presentation, I didn't feel that they carried as much punch as taking you to Mr Gaiduk's own evidence.
No, thank you.
So 822, very briefly, I agree with Mr Culver when he submitted that the Taruta Parties case requires the court to decide that in respect of 75 million and 7.5 million, Avonwick has not done what it agreed to do in exchange for the money. Yet all that Avonwick agreed to do in the Castle SPA was transfer the shares in Castle Rose. That, again, with respect, is just a wrong analysis, because it is proceeding on the basis that a claim in unjust enrichment can only succeed essentially in circumstances where there's a breach of contract. And that, in our submission, doesn't do justice to the concept that we will see from the case law, which says that a claim in unjust enrichment is not confined to circumstances in which there is a failure to deliver a contractual counter-promise, or to deliver the consideration in the sense of the contractual counter-promise. The claim can be sustained, we will say, in circumstances where the basis for which a payment has been made has fallen away or has failed to sustain itself, and that is this case. And just following that through in paragraph 823, it's not appropriate to do what Mr Calvert describes as the Taruta Parties inviting the court to somehow to look through the terms of the Castle Rose SPA and decide in some abstract way that they have paid for something other than the shares in Castle Rose. The truth is that without the alleged 2009 Shells Agreement being found to exist, there is simply no basis on which it can be concluded that any part of the consideration agreed in the Castle Rose SPA has failed. As Mr Culver also submitted, this is not a surprising result, since if parties design a bargain in a particular way and conclude a binding contract on that basis, it's not then open to them to claim a restitutionary remedy. So as I say, putting it very shortly, the judge is simply saying the Castle Rose SPA is a contract, it says what it says, therefore the claim in unjust enrichment can't succeed. Then, very quickly, to wrap up, you'll see from paragraphs 825 onwards, his lordship deals with the question whether, if there had been a claim in unjust enrichment, it would have been time barred. And he reaches the conclusion at the bottom, 834, 835, that the claim in unjust enrichment would not be time barred if it had succeeded. And again, there isn't any appeal in relation to that. I don't think then the judgment goes on for a goodly few pages beyond that, but for the purposes of this appeal, I don't think we need to dwell on it. So, just to step back before turning to the law and identify what the sort of battle lines aren't. First of all, it is the case that the judge found, and we are unable to appeal, that there was no binding contract for the transfer to the Taruta Parties of the Gaiduk Parties' interests in NET and Agro Holdings. We accept that, no binding contract. Secondly, we accept, obviously, that on the face of the Castle Rose contract, the sum of 950 million is stated as the price payable by Dargamo and Azitio in equal shares to Avonwick in exchange for the transfer of Avonwick's shares in Castle Rose. But thirdly, we submit that it is clear from what we have seen of the pleadings and the evidence and the judgment that it was common ground that the three principals agreed that the number that appears in the Castle Rose SPA, the 950 million, was calculated on the basis that 750 million was attributable to the shares in the Castle Rose, and the additional sum, as the judge called it, was attributable to other assets. Fourthly, specifically, it is common ground that of that 200 million additional sum, 150 million was attributable to the Gaiduk Parties' interest in NET, and 15 million to the Gaiduk Parties' interest in Agro Holding. And you saw very clear answers from Mr Gaiduk in cross-examination to that effect.
You've probably literally just taken us to this, so apologies, but just, does the judgment make that finding? Does the judge make that finding in the judgment? The split of the 150 and the 15?
Yes, I think that's paragraphs 6, 7,
yes,
6 to 9.
Sorry.
No, not at all.
You've just taken us to it, I know.
In fact,
6.
you have jogged my memory that the judgment also contained some unsuccessful re-examination of Mr Gaiduk.
Right.
Another object lesson in why not to ask questions in re-examination.
So just so you know, Mr Crowe, at the moment I've got very clearly 676, which is the 200 global, but I just can't, and I may have missed it, I can't find a finding as to the precise division down into 150 and 15.
Right. I will come back to you on that if I may. While you jogged my memory, can we just actually just go back to page 264 of the judgment, so the core bundle, tab 9, page 264. I should have taken you to this extract because it's not included in the supplemental bundle as a transcript, but it's quoted by the judge. Paragraph 653, Mr Foxton, he says, additionally made reference to certain evidence which Mr Gaiduk gave during the course of re-examination, which Mr Foxton submitted supports the Taruta Parties' case. That agreement was reached at the meeting on the 13th of December, and the fact that MAU4 lacks certain formalities doesn't matter. The exchanges to which Mr Foxton referred are these. Question. Now, on the first of those two questions, I want to ask you, did you have a meeting with Mr Mkrtchan and Mr Taruta in Kiev between the 15th of December 2009, to which no doubt counsel would have liked an answer yes or no, but he got instead, my lord, the last meeting we held was no later than 13th December. I don't remember the exact date, but it was no later than 13th December. As a result of that meeting, Mr Petrov introduced amendments in the memorandum, and on the 14th, with the date as of the 15th, he sent it to Mr Tkachenko automatically to all the partners. So he introduced the changes or the agreements that we had struck, we had agreed, what we had agreed, the Dubyna and other aspects, all the components. And I think it was the same meeting, 13th or before 13th, we rounded up the sum, the amount, I don't exactly remember when. And then Mr Calver asks, at the time, Miss Gaiduk, did you see this track change document that we see on the screen? And this is MOU4, which is tab 1, I think, in the supplemental bundle. No, it's not tab 1, it is tab 2 in the supplemental bundle. No, my lord, this document was never sent to me. It was put together after the meeting we had, so it's never addressed to me, never sent to me. Did you ever signify to anyone else that you agreed to what was in that document? Well, it states here what we had agreed upon de facto. This has recorded what had been discussed by us, and it was then compiled, it was drafted after the meeting had finished. So again, I don't want to take time going through that.
So I'm just wondering whether at 818 the judge actually isn't taking the very simplistic approach that you suggest at the end, and actually what he's saying is that there wasn't a specific, what he was saying in code was there was no specific agreement as to precise figures on apportionment unless you had been able to establish the precise shareholders' agreement.
Right.
Do you see what I mean?
Yes, I do. If that's what the judge is saying, in our submission, it is wrong, and it is allowing his adverse finding as to the absence of a 2009 shareholders' agreement to infect what was the clear basis upon which not 750 million, but 950 million was stated as the contractual counterpromise in the Karlsruhe's SPA. If all the judge was saying is the words at least 75 million mean that there wasn't actually a binding agreement at 75 million, as a matter of contract, I accept that. But in terms of unjust enrichment, has a benefit been conferred? Yes. The additional sum is 200 million. Conferred by the claimant on the defendant? Yes. Is it unjust? Yes. Because even if there is some element of uncertainty as to the precision, it is in the aggregate a figure of 200 million, not referable to what was ostensibly the subject matter of the contract.
But that's why I'm concerned that we do need to know more about the other deals, because if you're going to take the aggregate approach, we've got to look as whether or not there was a total failure of consideration in relation to the 200 million, and there seems to have been a lot of activity within that umbrella.
Yes.
So it doesn't work, does it, from your point of view? You've
that
got,
is why I took you to
establish the 15 and the 150.
Yes. Well, that is specifically why we took you to the cross-examination where Mr. Gaiduk made those admissions.
I understand.
And he does specifically answer those two numbers. And you
don't pursue an aggregate approach then?
No, sorry. I was merely slightly forensic flourish when I referred to the 200. But on the face of the pleading from the Gaiduk parties and on the face of the evidence that Mr. Gaiduk gave, the 15 and the 150 for NET are both clearly admitted. So yes, I'm not taking the aggregated approach on the 200. So yes, just getting back to I was giving you a little list of things that aren't an issue. The last 2 points are that it is common ground that Dargamo and Azitio did pay the 950 million. And it is common ground that the Gaiduk parties have not transferred to the Taruta parties their interest in NET or in Agro Holding. Turning to the law, there again, it may be convenient just to start with things that are not in dispute. The first is that, as we have seen, English law applies to the claim based on unjust enrichment, and there's been no appeal against that. That was paragraphs 770 to 776 of the judgment. Secondly, as we've seen, if a claim in unjust enrichment can be sustained, it would not be time-barred. And we've seen that from paragraphs 825 to 834 of the judgment. Thirdly, we've seen, subject to oral submissions as to relevance, we have seen that the Gaiduk parties are not seeking to rely on the entire agreement clause as such. Fourth, you will have seen in the judgment that we relied in the court below on a number of insurance cases dealing with a slightly arcane point called the Fairchild Enclave, which we are not pursuing in this court. They are a very bespoke set of decisions.
Does that also IEG goes?
Yes, that's right. That's right.
Just before the train goes on, I'm sorry, take off my mute. He said it was common ground that we're not relying on the entire agreement clause. As I said when he opened, and my lady mentioned it, we do rely on it in the sense that it's part of a contract, and it says this contract states that this is the full extent of the contract and there are no collateral contracts, etc. So if my learned friend is proceeding on the basis that that is not a submission that we're going to make, that is to say that the Castle Road SPA in clause 2.4 sets out the full extent of what the consideration is for, then I'm sorry that he has been misled by something you said.
Maybe my fault. I'm sorry.
No. It's helpful to have these clarifications early. But I'll wait to hear what my own friend says. But could I just perhaps preemptively say this on the entire agreement clause, since it's come up? Clearly, self-evidently, the function of an entire agreement clause is to delimit the scope of the contractual parties' contractual agreements. And therefore, by definition, it says nothing about the availability of a remedy in unjust enrichment, which does not involve any attempt to enforce a contractual obligation. If we had a claim in contract, the answer may well be in the entire agreement clause. And secondly, and in any event, obviously the entire agreement clause is only operative as between the contracting parties, which is the corporate entities. Whereas, as we have seen, the understanding which forms the basis on which the additional sum of 200 million was included was an understanding reached between the principals, not between Avonwick, Dargamo and Azitio. And it is therefore not available in response to a claim against Mr Gaiduk to procure the repayment of that sum.
But it's also the company's claim.
Yes, indeed. Yes, I mean the company was the payor, yes. But the basis upon which the company made that payment was a basis agreed between the principals, and they are not bound by the entire agreement clause. The final point that isn't in dispute before we get into the law is this. My learned friend, you will have seen from his skeleton, is not seeking to persuade you that a claim based on unjust enrichment can never succeed where there is a valid and binding contract.
Preserving his position on that, but that's what he's prepared to accept for present purposes.
Yes. Section B2 of his skeleton discusses the exceptions to that rule. So the debate in front of you is a debate as to the scope of those exceptions.
Again, I have to take my mute off, and I'm going to try not to rise again. I think it's perfectly clear what we say. The exception, if any, is very narrow. So,
yes.
To the extent, it depends on what a learned friend wants to express it. The existence of a binding contract does not necessarily mean you can't have a claim. Well, that's clear from bonds. But it rather depends on the nature of the claim.
My Lord is now advancing submissions rather than clarifying anything. He has in fact just confirmed what I said, which is that the debate in this court is a debate as to the scope of the exception.
Yes, Mr Oleh, as said, the exception is very narrow.
Yes, and the word rare comes up more than once. Now, before going to the case law, can I just offer some propositions of law so that you can see why I'm going to take you to what I take you to and it hopefully just set out what I'll stall. The first point, I trust, is entirely uncontroversial, and we've already seen it in the judgment, paragraph 800, which is that the three core elements of the claim in unjust enrichment are, obviously, that the defendant has been enriched. Second, that his enrichment has been at the claimant's expense. And thirdly, that the enrichment is unjust in the eyes of the law. Second point, we accept that in general, the fact that a payment is made pursuant to a subsisting contractual obligation means that it is quite likely that the benefit thereby conferred on the payee may not be regarded as being unjust, but that there is no inflexible rule to that effect. Our third proposition is that, whether it's common ground or not, we would submit that it is clear that a claim in unjust enrichment can be sustained, notwithstanding the fact that a payment has been made pursuant to a contractual obligation. If there has been what is described in the case law and the commentary, if there has been a total failure of basis. The old expression, total failure of consideration, has been falling out of favour because it focuses unnaturally and unnecessarily and wrongly on the purely contractual counter-promise. So total failure of basis is the test. Our fourth proposition is that that principle, namely that a claim in unjust enrichment can be sustained, notwithstanding the fact that a payment has been made pursuant to a contractual obligation, if there has been a total failure of basis, that principle applies even where the payer has received some benefit under the contract. So long as the payment he is seeking to reclaim can readily be apportioned to the relevant part of the basis which has failed. The fifth proposition is that for these purposes, we submit that the basis on which a payment is made is not confined to the contractual counter-promise of the payee. And finally, the basis on which a payment is made is to be ascertained by considering all the relevant circumstances. In a sense, those two are just the corollary of each other. With that, can we start with the Australian case of Roxburgh, and Rothman of Pall Mall, which is in the second volume of Authorities, tab 9. You may already be familiar with this, so forgive me if I'm telling you the outline that is already familiar, but essentially the case arose in these circumstances that the state government imposed essentially a disguised tax on tobacco products. It was called a license fee, but it was held essentially to be a disguised tax, which the wholesaler had to pay, and the wholesaler laid off the costs, so to speak, of that to the retailers who bought from the wholesaler, and the intention, all other things being equal, that the retailer would lay off the cost to the retail purchaser. But the courts found in other proceedings that that license fee, so-called, was a disguised tax which was unlawfully imposed. And so the wholesaler, having received payments from retailers, which included an element representing the license fee, the wholesaler has received those payments, does not then have to pay over the license fee element to the Revenue and Customs. So the retailers say, well, could we have that back, please? And they make a claim in unjust enrichment. The question is whether or not that claim can succeed. And as we will see, the two things that we invite you to get from this decision are that the retailers claim to recover that element of the price which they paid to the wholesalers. That claim in unjust enrichment succeeded, even though the sums paid by the retailers to the wholesalers were paid pursuant to a contractual obligation. Second, the wholesalers were not in breach of any contractual obligations to the retailers. And thirdly, the retailers received the tobacco products they had paid for. So what you get from that combination of factors in this case we submit is there can be a total failure of basis under a contract where a party has not received a relevant benefit, even though it has received a substantial benefit, and even though the payment is made pursuant to a binding contractual obligation, so long as the element of the payment that is sought to be recovered is readily identifiable. And for these purposes, it is clear as we go through this authority that the basis which has failed is not limited simply to the contractual counter-promise, because there was no contractual promise either to pay. There was no contractual promise between the wholesaler and the retailer, either that the wholesaler would promise to pay the tax to the tax authority, or that it promised to repay to the retailer if it didn't have to account to the tax authorities. So, if we turn to, if we've got the authority open, picking it up, the judgment starts at page 450, well, the majority starts at page 450. There's quite a lot that's been sidelined. I would invite your attention to those passages, but I would like, on my feet, just to draw to your attention some other elements which are not necessarily sidelined. So could I just start actually at paragraph 5? I'm not suggesting anything sidelined is irrelevant.
Yes, Mr. Crowe, the suggestion as to what we should read from the reading list was not limited to the sideline passages. And so I, at any rate, have read some bits of it, but please take us to what you'd like us to focus on.
I'm very grateful. Just by way of context, paragraph 5 is instructive when one is dealing with the concept of unjust enrichment. Because what the majority say is, in all probability, whoever succeeds in these proceedings will have made a windfall gain.
Yeah.
In the absence of some legislative intervention, the appellants, if they succeed, that's the retailers, are unlikely to be obliged to pass on the fruits of their success to the smokers, who bore the financial burden of the invalid tax. For its part, the respondent, that's the wholesaler, has collected what was held to be a tax on goods, but it has not had to pay it over to the revenue authorities. Leaving the cards to lie where they fall is a possible approach, one which Lord Shaw of Dunfermline once said works well enough amongst tricksters, gamblers and thieves. It may also work well enough in cases where there is no contractual or other relationship between the parties and no coherent legal principle to dictate any other outcome. But here, we are concerned with reputable commercial people who entered into ordinary business dealings and whose expectations were defeated by the supervening illegality of one aspect of those dealings. They made contracts. The justice of the situation in which they now find themselves must lie in the principles of law and equity which governed their dealings. Those principles, in turn, must be related to the contracts into which they entered. Contracts, both in form and in substance, were strongly influenced by the prevailing fiscal regime. So one sees there both an overarching principle of an approach to achieve justice by reference to principle, but also to look both at the contract itself, but also the circumstances in which it is entered into, the prevailing fiscal regime. Then go on to page 454. This was, I think, part of the recommended reading list, but I just wanted to emphasise paragraph 16. Failure of consideration, the language is still being used there, we would now say failure of basis, but failure of consideration is not limited to non-performance of a contractual obligation, although it may include that. That, in our submission, is a critical finding. The authorities referred to by Justice Dean in his discussion of the common law count for money having received in Mkrtchan and Dodds show that the concept embraces payment for a purpose which has failed, as, for example, where a condition has not been fulfilled or a contemplated state of affairs has disappeared. Justice Dean, referring to general equitable notions which find expression in the common law count, gave an example. So that, in our submission, is a critical part of the reasoning. It's picked up again about halfway through that paragraph after a number 45 in brackets. In the case of money paid pursuant to a contract, it would involve too narrow a view of those general equitable notions to limit failure of consideration, we would now say failure of basis, to failure of contractual performance. So clearly, the significance of that for our purposes is that the fact that there is no contractually binding obligation to transfer the Gaiduk Parties' interests in NET and Agro Holdings does not mean that you are forced to conclude that our claim in unjust enrichment fails, because the basis upon which the 150 million and the 15 million elements of the contractual payment were paid have not been fulfilled, to use the word language of that paragraph. And then over the page, page 455, paragraph 70.
And in effect, it's the opposite way around here, because what's being said is actually they got everything they thought they were going to get under the contract. They got their goods, etc. But that's not an impediment.
Yes, that's right. Exactly. Exactly. Paragraph 17. Again, just to emphasise the passages which we particularly rely on. In a contract for the sale of goods, the total amount which the buyer is required to pay to the seller may be expressed as one indivisible sum, even though it is possible to identify components which were taken into account by the parties in arriving at a final agreed figure. And that is exactly our case. The final agreed figure itself may have been the result of negotiation, making it impossible to relate a cost component to any particular part of that figure, or there may be other factors which prevent even a notional apportionment. But there are cases, of which the present is an example, where it is possible both to identify that part of the final agreed sum which is attributable to a cost component, and to conclude that an alteration in circumstances, perhaps not involving a failure to incur an expense,
Perhaps involving.
Perhaps involving a failure to incur an expense, has resulted in a failure of a severable part of the consideration. And that, again, in our submission, applies all fours to the case in front of you. And then the last 4 lines of that paragraph. The state of affairs which was within the contemplation of the parties as the basis of their dealings concerning tax liability altered, and it did so in circumstances which permitted and required severance of part of the total amount paid for the goods. So again, we would submit that that is on all fours with a situation where, effectively, the Taruta parties paid an advance against anticipated future binding contracts for the transfer of those additional assets, but those future binding contracts were never entered into. If we just go over and emphasise and explain why we sideline paragraph 20. And the context, just to give it to you before reading, is this, that one of the main points that my learned friend seeks to make is that where there is a contract between the parties, unjust enrichment should not be allowed to operate so as to cut across the allocation of risk, as he would say. Now, paragraph 20 demonstrates in our submission that that argument can't be sustained, because under the contract, the wholesaler was entitled to hang on to the tax element.
And that's exactly why Justice Kirby decided the other way.
Exactly so. But the majority were quite clear that unjust enrichment certainly can produce a different outcome, a different allocation of risk, if you like, from that under the contract. And the reasoning for that appears in paragraph 20, the articulation that although an attempt was made by the appellants to invoke an implied agreement under which they could claim repayment of any unpaid tax, it was artificial and unconvincing. The parties made no agreement, express or implied, about what was to happen if the tax was held to be invalid. If there is here a right to enforce repayment on the basis of a failure of consideration, it is because in the circumstances the law imposes upon the respondent an obligation to make just restitution for a benefit derived at the expense of the appellants. If there had been a total failure of consideration because, for example, there had been a prepayment for goods which were never delivered, the respondent's duty to make restitution would have been clear. But there are 2 questions. The first is whether there has been a failure of a severable part of the consideration. The second is whether, in the absence of restitution, the respondent will retain money at the expense of the appellants. But the starting point, the important point to meet my learned friend's reliance on the contractual allocation of risk is that the court expressly dismissed the argument that there is an express or implied term on which the retailers could succeed. So the contract did not deliver the outcome, which is why unjust enrichment had to be invoked. We then just go on, you see that on page 459, Justice Gummo gives his concurring judgment, and again there's quite a lot sidelined here. I just wanted to emphasise in particular one paragraph that we haven't looked at on 468. Sorry, we didn't emphasise paragraph 62. The appellants rely upon the principle encapsulated by Viscount Haldane in Royal Bank of Canada and the King. In a passage later adopted by Lord Wright, his lordship said, "It is a well-established principle of the English common law that when money has been received by one person which in justice and equity belongs to another, under circumstances which render the receipt of it, a receipt by the defendant to the use of the plaintiff, the latter may recover as for money had and received at his use. The principle extends to cases where that money has been paid for a consideration that has failed." And that's a sort of starting point for the discussion. And if we then go on to 474, you'll see the heading, the decision in Moses and McFarlane, which is given a considerable amount of discussion. There are just a couple of short passages which are not sidelined. I wanted to draw to your attention under that heading. If we look at page 477, paragraph 83, Lord Mansfield spoke of the action for money hadn't received as one which lies in numberless instances as founded in the equity of the plaintiff's case, and as a kind of equitable action to recover back money which ought not in justice to be kept. The question being whether the defendant may retain it with a safe conscience. Later
we're dealing with a common law remedy, aren't we?
Yes.
I mean, so it's really important, and the authorities make it clear, don't they, that when we're looking at the question of unjustness, we are looking at whether or not this is a case, for example, of mistake, undue influence, or you would say total failure of basis. We're not looking, is this right, more broadly at what we think is fair?
Well, the concept of unjust enrichment, the clue is in the name.
Yeah.
If you come to an outcome which is dictated purely by reference to the kind of hard-edged rule that my learned friend would seek to invoke, namely, there is a binding and subsisting contract, and there are exceptions which were in hermetically sealed units, you are not delivering an outcome which is founded on the concept of unjust enrichment. So we do urge these passages on you in order to give value to that concept, because my learned friend is seeking to take an approach which essentially just acknowledges that there are exceptions and then says, oh, well, the factual circumstances of that case, Roxburgh and Rothman of Pall Mall, the facts of that case were this: it was a tax. Therefore, the justification for that exception is purely if the benefit has been paid in relation to an obligation which was externally imposed. And he reverse engineers a limiting rule by reference to the facts of the case. And in our submission, that is the wrong approach to a concept which is founded in unjustness of the enrichment. That is the third element. What is unjust? If we just go over...
and just so that I'm clear, Mr Crowe, what do you say, therefore, are the factors that we take into account in order to determine whether something is unjust?
Whether the basis upon which the benefit that has been conferred and is sought to be recovered, whether the basis,
failure of basis
has failed.
So as my lady said, failure of basis, mistake, whether you're under specific headings, you're not asking us to evaluate whether something is unjust or not.
Not in the abstract, no. I entirely agree that there has to be a principled approach. Yes, I entirely agree with that. Can I just remind...
So do you say, forgive me, do you say in any situation where there is a relevant contract, if there is a failure of basis outside that contract, there lies a claim in unjust enrichment in every case?
Well, I don't have to make that submission, and I don't make that submission. What we submit is that the elasticity in the concept of unjust enrichment allows you, by reference to the facts of a case, the case in hand, to decide whether, if there is, first of all, a clear basis for which a payment has been made which has failed, and secondly, if what is being claimed, if the repayment that is being claimed can clearly be apportioned to that failed basis. In those circumstances, the court can reach the conclusion, should reach the conclusion, that leaving the money with the payee would be unjust. What I am seeking to resist is my learned friend's attempt to, as I say, to derive from the case law sort of fact-specific rules which are added to the failure of basis and the apportionment principle, and say, well, you've got to be able to identify a failure of basis which is, the particular point and that I think he tries founding on Roxburgh, is that the obligation, as it happens on the facts of that case, to pay the tax was externally imposed. And he seeks to say, well, therefore, it is a necessary part of an exception to the rule that, in general, you can't claim for unjust enrichment in relation to an existing and subsisting contract, that exception only exists, he would say, in relation to a situation where the claim, the money that is being sought to be reclaimed, was a non-negotiable, externally imposed element of the contract. That is simply no part of the ratio in our submission in Roxburgh and Rothman, and it would simply impose an unnecessary and unprincipled restriction on what is an open textured question. A principled question, but an open textured one. The third element is, was the enrichment unjust? That should not be confined to a sort of predetermined list of factual circumstances.
Are you going on from 83?
I was going to go to page 484, where the court discussed failure of consideration, and having quoted, this is sidelined, but having quoted the different meanings of consideration in paragraph 101, Justice Gummo says at 102, it's the third meaning with which this litigation is concerned, but what is meant here by the term consideration? It is important to appreciate that although this often is the case, the bargain referred to in describing failure of consideration need not be contractual in nature. And that, in our submission, is important in the context of a case where, as we have pointed out, Mr. Gaiduk's own evidence refers to the deal and so on being the deal between the principals, which defines how the consideration is actually calculated and then paid under the contractual arrangements. And then just over 486, again, just to pick up some particular passages in the sections that are sidelined. Paragraph 104, we place particular reliance on. In the present case, there has been no failure in the performance by Rothmans of any promise it made. Now that, it is an important, it's not just a factual point, it displays a principle that inheres within the unjust enrichment remedy, which is that a claimant who has made a contractual payment can recover that payment, notwithstanding the fact that it is the repayment is being sought other than in circumstances where the payee has been in breach of contract. And so the mantra that runs through the judgment in this case and my learned friend's submissions, that the contract says what the contract says, is not in our submission a complete answer. It's not an answer at all. His Lordship then goes on a few lines later. Is it unconscionable for Rothmans to enjoy the payments in respect of the light tobacco licence in circumstances in which it was not specifically intended or specifically provided that Rothmans should so enjoy them? The answer should be in the affirmative here. Failure of consideration identifies the failure to sustain itself of the state of affairs contemplated as a basis for the payments the appellants seek to recover. Now again, on the facts, my learned friend makes much of the fact that the invoices from the wholesalers to the retailers refer to the tax. Fine, that's a factual point, but it is simply an evidential point for identifying the apportioned sum which is sought to be recovered. It's not a precondition to recovery that there should be an invoice that identifies a particular sum. That happens simply to be the evidential basis upon which the need to apportion, to identify the sum that's being reclaimed, referable to a particular basis of the contract. And in our submission, we don't get it from the face of the contract, we get it from the evidence and from the pleadings. There are a couple of other passages in this judgment which we would particularly emphasise, really 106 and 107. But I think in light of the time and the fact that you have clearly had an opportunity to look at them, that was all I was going to
well,
take
Mr. Crowe,
you to.
You particularly want us to look again at 106 and 107.
Yeah.
Thank you. Thank you very much. I also have another question, which is, presumably we will be receiving the transcript, which is very helpfully rolling before us, in electronic and perhaps hard copy form. And I hope that we will receive them as soon as possible.
They do normally come out extraordinarily quickly. I will make sure that that is the case.
I'm very grateful. Thank you. On that basis, 2 o'clock.
Bye.